So I want to talk now about something really well known to attorneys that practice in personal injury, tort reform, maybe not necessarily commonly understood by the general public. You may have heard politicians use it, tort reform, and they use it in a way that it's something that needs fixing. Tort is really civil justice. Okay, so civil justice, but they don't want to use, for political reasons, they don't want to describe it as erosion of civil justice. So they use this catchy phrase, tort reform. Politicians and the big industry suggest reforming civil justice law and rules of civil procedure and putting caps on recoveries, etc. Products will be less expensive, manufacturing will be less expensive, companies will be more profitable, etc., etc. So it's all about saving money. Now that sounds good, and I'm all about saving money and reduction of government spending and government size and bureaucracy and things like that. I'm all about it. But tort reform is actually the opposite of that. So you have to go back. You have to step back for a minute and think about what the tort law entails. So tort law is civil justice, and in simple terms, that is the ability of the private sector, individuals, to have the ability to seek justice. So we all know the government has its ability to seek justice through the courts, police, prosecutors, and charging people and bringing them to court. So that's the sort of government side of justice, criminal law, some other regulatory law. But civil justice is for the population. It's for individuals. It's for businesses to be able to identify a harm. So if a harm has occurred, a harm or a loss, you yourself can bring an action, commence an action in the court system, and have access to a judge, have access to the rule of law, have access, most importantly, to juries. Juries are a phenomenal gift because it allows the individuals on both sides, both the party, the plaintiff bringing the action, and the defendant, the one that's being accused of causing some harm, to both have their facts decided by the community, by peers. And they both have a say in who ends up on the jury. Through their representation, they can challenge jurors, and they ultimately have a say on who those people are that will decide their case fairly. Just think about that for a moment. It's a remarkable, remarkable system. It's a gift. It's a beautiful system. And it's proven time and time again to benefit society in so many ways. Okay, so let's think about it for a minute. Let's just talk about products, for instance. Lots of things that we take for granted. I watched recently a continuing legal education event in Texas where one of the guest speakers, his whole practice is on vehicle safety. Vehicle safety. And so what happened was they started identifying, through lawyers around the country, started identifying that certain vehicles involved in routine, expected collisions, when the collisions had a certain dynamic, people were either getting maimed or dying. But then in other cars, it wasn't happening. So what was the difference? Why were some vehicles off the charts in terms of fatality and serious injury, while other vehicles could have the same accident or even a more significant accident, and the occupants largely were walking away? That's a perfect example of the civil justice system working effectively, because what happened is that attorney, who was a very skilled attorney in that particular area, has an interest in that area, was able to hire experts and engineers and conduct testing and crash testing, real crash testing data, and identify, for instance, I'll use an example I learned from that one, identify that simple things like a weld in a particular place would protect the occupants, or $4 or $5 worth of spray foam in a headliner would prevent the vehicle from completely caving in on rollover. And of course, that leads to litigation against the manufacturers. And it's strict what you need to prove. It's not as easy as everyone thinks, as the headlines make it sound. The lawyers need to do a lot of research. They have to prove a lot of elements and show that the manufacturer was negligent and the manufacturer knew better and the manufacturer could have and should have made that change for everybody's health and safety. And if successful, the damages are significant, very significant. That has resulted in those manufacturers adding a weld or adding some spray foam, etc. So that's an example. We all benefit. You can look out on the road and you see all these cars, and I'm in awe of how much we have benefited from litigation aimed at defects in consumer products. The same thing occurred with chemicals, fertilizers, pesticides, where ultimately certain additives and chemicals were banned or taken out of it. But all of that started because somebody in the public was harmed and they had a place to go, the courthouse, the civil justice system. And without that, those poisons would probably still be there. The cars would be a lot less safe. When you're talking about tort reform, what the government and the corporations are really attempting to do is to limit access to a civil remedy. And they do this in a number of ways. It's the same playbook always. And depending on the jurisdiction you live in, you may have more or less tort reform, depending on how much your government has caved to the demands of big business and insurance companies. Here are some of the common ways they do tort reform. Okay. And when you hear tort reform, keep in mind, it's taking away your civil remedy. It's taking away your ability in some way to go to the courthouse and seek justice for the harms and losses. So one way, capping damages, setting artificial limits on what somebody can recover in court for their harm and loss. In a really serious case with complexities like chemical cases, like product development and product defect cases, extremely expensive to prove those cases. You need a lot of science, a lot of data, a lot of discovery, often a lot of years of hard work and testing and science. And if the damages are capped, if the amount of money you can recover in court is limited, there is no opportunity to pursue those cases. The funding exceeds the recovery. Okay, so that's one way. Take the money out of it, and therefore the people will have less access to lawyers, scientists, engineers, etc., and therefore less ability to actually bring it to court and prove that case. Capping damages is harmful. It's taking away a civil remedy. It's undermining juries because there is protection already. There's, number one, the community, if it's a jury trial, deciding what they believe is the fair value for the harm and loss. These are community members. They consider the evidence on both sides. They consider the positions of both sides. In my respectful view, it's the most fair way to assess the value of a case. But let's say the jury does get it wrong. There's safeguards built in already. There's appeals. There's opportunities to get the trial judge to reduce on motion, to reduce the jury verdict. You can get a judgment notwithstanding the jury's decision or verdict. So there already are safeguards in place to reduce verdicts. So when industry and politicians parade around these huge jury verdicts, don't tell you all the facts and just say, another jury went nuts and gave away $100 million to someone. What they haven't told you is that there was an appeal and it was reduced to $10 million. They don't want you to know that. They don't want you to know that there are safeguards in place. And when the verdict sticks, after all of the evidence, that means even a judge, a court of appeal, has agreed that the verdict was appropriate in all of the facts and circumstances of that case. So the safeguards are there already. Caps on damages, clear way of reducing access to the court system for individuals. They don't put, what they don't put caps on? Big corporations, their claims. You'll never see a huge corporation be told, oh, you cannot go and sue your competitor we're going to put a cap on how much money you can recover. They'll never do that because the corporations still love to use the courthouse. They love to sue. They sue a lot more. That's an interesting fact. Corporations love to use the courthouse, but they don't want the general public to use the courthouse to hold them responsible. And they lobby and advocate for protection. Another key area of tort reform is eliminating juries in certain circumstances. I think the public should be outraged by it. Although judges are impartial, judges are either elected or appointed. Judges are not always in touch with the community. In my respectful view, I think there's no real substitute for a jury system. I think it's fair. The judge is the judge of the law. The jury is the judge of the facts. That's how it's always been. So the jury decides the facts. The judge is there to guide and make sure the law is applied correctly and applies all the questions of law. That bifurcation of duties, I think, keeps everybody honest, keeps the process fair, and also keeps the appearance of fairness, which is a big important feature of it. It allows the public to participate in a justice system that was built for the public. Taking away the public's participation as a means of tort reform really, I think, is a means of reducing access to justice, reducing interest in the court system, reducing reverence for the court system, and ultimately reducing people's use of the court system and trust of the court system. Amendments or changes that have been happening all around to rules of civil procedure in the name of efficiency. Okay, so the rules of civil procedure, we're talking about civil court. The rules of civil procedure is basically like if you're playing a board game, is basically the rules of how to keep it fair and what everybody's duties are and, deadlines, even up to the type of font and the color of the paper you have to use is all contained in the rules of civil procedure. But the rules of civil procedure also govern discovery, how much time you have with witnesses, how you depose witnesses, what you can and cannot subpoena. In the interest of efficiency, if that's really what it's about, the rules of civil procedure have been often amended in ways to what I would describe as blunting the sword, blunting the tools of the lawyers, of the litigants, really, to have a full discovery, to pursue justice to its fullest, to learn the facts, to uncover the circumstances. And they can say, well, it's on both sides. The defense is also limited. But the defense wants to be limited. They're the ones being accused of doing the wrong, the harm. It's the plaintiff that needs the tools of the court, the ability of the court, the power of the court to be able to compel the defendant, not going to call them accused, but the defendant in the action to produce people, records, documents, evidence. Whenever I see these amendments coming, they're always trending toward blunting the ability of the litigants to actually find out what happened and pursue justice to the fullest, in my respectful view. The other shortcoming of rule amendments that blunt litigators' ability is it takes away the skill. So now if you reduce the skill of litigators, you reduce the ability of people to go into court and seek justice. That's been a major trend all across North America, where there are fewer and fewer and fewer attorneys that go to court, fewer lawyers that have the skills to go to court. And so what does that mean? If you're unfamiliar with it, you're uncomfortable with it, you're afraid of it, it means less cases go, less lawyers want to take those cases, less access to justice ultimately. And I'm not saying there shouldn't be more efficient means for smaller claims, but the approach is not really, in my view, not really geared to snuff out the smaller claims. I think it's really geared to eliminate the larger claims. Here's an interesting scenario in the context of motor vehicle accidents. You probably heard of no-fault states and at-fault states. Those are the two kind of competing models of auto insurance law. Okay, so the no-fault system is a system where, irrespective of fault, so without accounting for fault, your own insurance company or the injured party's own insurance company is responsible for paying some of the immediate losses, medical bills, income loss, the typical things like that, some of the immediate harms and losses. The trade-off is less access to court. So the trade-off is, because you are able to recover some of your losses from your own insurance company, therefore, the theory is you don't need to sue the at-fault party, and it's better for everyone. You get immediate access to some funding, and you don't have to sue the at-fault party, and you don't have to go to court. However, the playbook is clear now. Okay, so wherever no fault has taken hold, the playbook is clear. The reason why they are establishing a no-fault system is because while you're looking here at the benefits that they're giving you for the no-fault system, what they're actually doing is taking away the right to a whole class of people injured in cars, taking away the right to go to the courthouse. The tort system, the civil remedy system that was built for you, where you could go and have your disputes resolved by your community, is taken away. All right. And at first, the insurance companies are very smart when they introduce this. They lobby hard. At first, they come in with a massive buffet and all you can eat of benefits through your own insurance company. So you're so busy and thankful that, wow, this makes my life so much easier. And I'm okay with that because I don't have to sue the at-fault party. The remedy is faster. It's better. It's compensating for a lot of things. And only in those very significant accidents is the door still open to the courthouse for pain and suffering. Many people are satisfied with the benefits they get immediately from their own insurance company. That's how it always starts. I've seen the trend. I've followed it. And as the years go on, here's what they did. They closed the door to the courthouse. Keep that in mind. In exchange for giving you this, they took away this for a whole class of people, or they limited your access to it significantly so that it's eliminated for many and is very narrow for others. Okay, the pathway to the courthouse. 5 years rolls around and they keep lobbying the government. Well, that buffet of benefits we gave is just too much. It's too rich, too expensive. Everyone's premiums are going up. It's unaffordable. We got to claw back some of that. We have to take some of that away. So they take some of those benefits away. The door here hasn't opened up at all. It's still closed. 5 years go by again. They take away more benefits. And before you know it, they have a generation that has accepted, become used to, complacent with the fact that they don't have access to the courthouse for a car accident because their parents got a very rich deal, but that deal's not there anymore. Now there's very limited, insignificant benefits available to you on the no-fault side, but the door is closed. They've conditioned you to accept that. They've conditioned you over a generation of people growing up with the understanding that we don't have access to the courthouse. We have no-fault benefits in this state. It's a scam. It's tort reform. It's a bait and switch. It's all it is. It's a bait and switch. The worst part of it is I haven't seen enough movement from the grassroots educating kids in schools about the importance of the civil justice system. I don't think the law schools do enough to educate future judges on the importance of the civil justice system. The politicians are listening to the insurance companies and ignoring their population. And when they close that door to the civil justice system, you take away the rights of the individual to self-govern, to self-police, to self-correct the harms that occur. And so what I plan on doing in the not so distant future is I want to bring on some of these remarkable lawyers that have really carved out a niche area with specific products, environmental, things like that, so they can really come and share their story on how it was their litigation or their field of litigation, lawyers like them, that really had a significant impact on all of our well-being, our health, our safety, whether it's lead, whether it's tobacco, whether it's safer cars, whether it's yellow extension cords so you can see them, whether it's slip and fall signs, chemicals in pesticides, chemicals in fertilizers. All of this stuff was possible because of access to the courthouse. And so when you take away that, where does the future go? I think it really starts with inspiring young people to have a reverence, to grow up with a reverence for the justice system overall, for the courthouse, for what it means, for the fact that it belongs to you. We think about the courthouse as belonging to the state, where they can prosecute people and throw them in jail. But it doesn't belong to the state. It belongs to the people. The courthouse is for the people, and the jury is for the people. It's by the people, for the people. It really is, right? And so you have this division of the decision-making powers between judge and jury. And I think it really starts with reintroducing it in a different way, in a better way, I think, in a more inspiring way to the youth through education, to reestablish a reverence for it. It's not an accident that the courthouse was a proud monument in many small towns. You can travel to all these small towns and you'll see, sort of the centerpiece of the town is this beautiful courthouse. There's a reverence for it. There's a pride. But through this lens of tort reform, that's taken away. That's being eroded. In fact, the insurance industry and the big lobbyists did a really good job of making the term trial lawyer a dirty word. Trial lawyer associations had to change their name. They started calling themselves justice associations to counter this narrative, this propaganda, really, to make tort and trial and the courthouse and the civil remedy system, to give it all these negative connotations, when it's really added so much to our society, to our health, to our safety. But I'm going to get some of those trial lawyers in here, and you'll hear what they've actually done. So that's a topic that I just wanted to speak about today. I know it's a little bit different than what we usually talk about. If you've got any suggested topics, questions, leave them in the comments. Would love to hear your questions and suggestions and hopefully turn it into a future video. Thanks for listening.